All right, guys. Awesome. Well, welcome everyone to the South Texas Multifamily and More Houston chapter virtual meetup. We're excited to be launching our new meetup under this new umbrella. So glad you guys can all participate. We got a very, very special guest for you tonight to talk about SEC law and how that applies to apartment syndication and everything that you need to know in between. So we kind of already went around the room here and kind of introduced ourselves and did a little bit of networking. So without further ado, Melvin, you want to go ahead and introduce yourself?
Sure. First of all, thank you for having me. My name is Melvin Ferebee. I'm a corporate securities attorney. I've also got a commercial real estate practice. Born and raised in Newport News, Virginia. Went to college at the College of William and Mary, where I played football. Graduated from college and worked in the hotel business for a while. Ended up going to law school at the University of Texas. Through law school, I worked for a firm where I structured private placements for bars, restaurants, hotel owners. And when I moved to Houston, I started doing the same for multifamily owners. As I mentioned briefly, I also represent producers and do these same private placements for production companies. So if you're raising capital and need it structured properly, that's what I do. I've also got a commercial real estate practice. So as most of you know, there are multiple transactions going on during a syndication. You've got the underlying purchase of the property, you've got the actual capital raise, then you deal with lenders. And so I take Texas clients through the commercial property sale and the capital raise simultaneously. So I've also got 4 kids under 8, so that's about me.
Oh my goodness.
Love it, man. Love it. Well, obviously, man, the purpose of tonight's meetup is, most of us are interested or, have heard about apartment syndication and are interested in learning how we can legally raise money to go out and acquire real assets like apartment communities or real estate in general. So tell us a little bit more about exactly what is real estate syndication or apartment syndication.
So let's start with the Howey test. So you guys decide you want to purchase a piece of commercial property, like an apartment complex, and you want to pull together money from investors to do so. So you're going to have a sponsor like, John and Cody, and they're going to, through their efforts, hopefully create a return for an investor. So the investors are going to be passive. Cody and John are going to be the active sponsors of the deal. And they're going to sell a piece of that business, the LLC and limited partnership that they're going to use to structure the deal to raise the money. That under Howey is an investment contract, and it is the sale of securities. When you sell that interest, that membership interest in the LLC or the limited partnership interest, you are selling a security. Under normal circumstances, you have to register that security. But there are exemptions under which you can escape registration, and most of them are under Regulation D, and most people raise under either Rule 506B and 506C. So a syndication is basically pooling money from investors to buy property and structuring that through the SEC laws appropriately to be exempt from the registration requirement.
I guess just to start off on a base level for everybody, what is the SEC and why is it important to us? And then for everybody who's joining, feel free to ask questions or post it in the comments, and we'll get to them.
So the SEC is the Securities and Exchange Commission. It is an independent federal agency whose primary jobs are to protect investors and to facilitate the sale of securities. It is a creature of the SEC Act of 1934, and again, the federal government they're interested in reducing fraud. So that's what the SEC does.
And at what point in the process should someone reach out to an SEC attorney in the syndication process?
When you're evaluating a deal, or you're thinking about I prefer if you're thinking about evaluating a deal. And you think, okay, I want to go and purchase this property, I want to raise money, contact me. If you receive any kind of investor disclosure document, whether it be a prospectus, a PPM, which is a private placement memorandum, and you're asked to invest, contact me. Again, if you're structuring a deal, it needs to be structured properly. If you're investing in a deal, it needs to be structured properly. And it's worth an hour or two of my time to make sure that that happens. So, like I said, if you're thinking about raising money to purchase property or at all, or if you receive some investor disclosure documents from a third party, give me a call and I'll take a look at it.
Yeah, and let me pile onto that one. If you're an investor and you're putting up $100,000 into a deal, that is the governing document, and some documents cannot be investor friendly. So you just need to be made aware. That might be okay, but you need to be made aware of what rights you may or may have against the general partner as a limited partner, and some of the provisions in there, which is exactly what Melvin's referring to.
Yeah.
All right, Melvin, going back to your original example. So John and I, we're partnering up, we're going out and we're going to buy a big piece of real estate. We want to syndicate, we want to pull people's money together. Can we just do that from anybody, or can you define what the SEC considers a certain type of investor?
Yeah, so no, you can't do it from anybody. So let's think
You're going to jail if you do that.
That's right.
Let's think about the policy behind this. So if you were to say you want to, raise money to buy property in Houston, and you've got a deal together, and you want to raise money from Bill Gates, okay? You're never going to reach Bill Gates. You're going to get it to a secretary. Maybe you're in a group with his attorney or his wealth manager. That attorney is going to look at that deal. The wealth manager will look at the deal. The CPA will look at the deal. Risk will be mitigated before it ever reaches Bill Gates' desk, right? Well, Bill Gates has the income and the sophistication level that he probably, he has those professionals on retainer. So he has an attorney on retainer, he has a CPA on retainer, he has a wealth manager on retainer to help him assess and mitigate risk, okay? Bill Gates is an accredited investor. An accredited investor is an individual with $1 million net worth, or their net income over the past 2 years was $200,000 as an individual, $300,000 if you're married, and you've got that expectancy for the third year to make the same. You also, if you have an entity with $5 million in it that what you created are motivated by this current raise, then that's also an accredited investor. But for purposes of this, the net income of $200,000 or $300,000 and then $1 million net worth. The idea being those individuals have professionals on retainer to help them assess and mitigate risk. So with accredited investors in a 506C deal, you don't have to provide them any disclosures because the idea is their professionals know what questions to ask. Now, there are people with great jobs, with great educations that go to meetups, understand what investing is, that essentially can evaluate a deal, right? They're financially savvy, but they don't meet that $1 million net worth level or the $200,000, $300,000 net income. They still should be able to invest according to the SEC. So, but they're not going to assume they know the questions to ask. They're going to require the sponsor to disclose everything about the deal profile, all the material risks, et cetera. That's the PPM. And the idea is if I, as a sophisticated investor, get that document, I will hire an attorney, I'll hire a CPA, I'll hire a professional to help me assess and mitigate risk. So that's why with sophisticated investors, the 506B raise, you can have up to 35 of them and an unlimited amount of accredited investors. And in 506C, you can have accredited investors only and third-party verified accredited investors. So that's the difference. And the policy is who has the team in place to assess and mitigate risk versus who's going to go out and hire a team kind of piecemeal to assess and mitigate risk, if that made any sense.
Yeah. Melvin, don't be humble, man. You know Bill Gates, man. Come on.
Yeah, I wish.
Don't be hiding out on us, man.
Hey, Melvin, to take it back a couple steps, I know for just some of our new investors, or when we put it up on YouTube, those are just stumbling upon this. Can you kind of break down why we're even talking securities in the first place? Because in my mind, securities are like stocks and bonds and stuff like that, right? Why are we talking securities for syndication?
Because the way these deals are structured, there's going to be an LLC form or a limited partnership. And you've got third parties that are going to be investing money by buying interest in those entities, with the expectation that the sponsor's effort's going to generate a return. That, under the Howey definition, is an investment contract, thus it is a security. So we can be dealing with membership interest in an LLC, limited partnership interest in a limited partnership, and in some cases you've got debt securities as well. So notes can be securities. So that's why we're talking about securities. If you're investing, you're purchasing a piece of a company that's going to own property, but you're going to be passive. You're not bringing anything to the table but your money. And we're hoping that you are going to help generate a return, then SEC law applies. Now, you can also have a joint venture, which I get this question a lot. How does a JV differ from a syndication? Well, if Cody and John are bringing something to the table, one is bringing operations, one is bringing business development. And then you've got Abels and Jarvis that are bringing construction and asset management. And you guys are going to pull money together, and the combined effort of the group of that joint venture is going to purchase the property and manage it. Now you're in a different level. You're not really dealing with securities. All of you are expected to share on the upside and the downside of that business. You're all assuming that risk. There's not one or two of you that are going to rely on the other to generate a return. So that's where that's where we're dealing with joint venture versus security. So think passive investors, expectation of return, and a common enterprise security.
So then follow-up question. So you mentioned JV. Is there a maximum number of people you can have in your JV?
No.
Okay.
As long as everybody is bringing something to the table, they're all going to be active, and you don't have that expectation of a return generated through the effort of just sponsors, then you can have as many people in the JV as you want to. It can get cloudy, from a business standpoint, but no, you can have as many as you want.
So the minute you bring on a passive investor, that's when you have to register with the SEC. Okay.
A lot of people know. So we're getting away from the registration requirement. We're going to find an exemption. Okay. That's with the 506B, 506C, and in some cases, regulation CF or A+.
Yeah, I think correct me if I'm wrong, Melvin, the intent of return is really where the break point between the JVs,
the intent of return based on the efforts of just a sponsor. So if I'm investing money in your enterprise and I'm passive and I'm hoping that you and John are going to do your efforts generate a return, I've just purchased security. And you want to make sure that's very clear. So JVs often get in trouble because it starts off with that combined effort and everybody brings something to the table, and then they need a little bit more money, so they bring on a passive investor. At that point, you switched over to securities and you've got to properly protect you.
From a syndication standpoint, I know you mentioned that, all of us have a role. What red flags have you seen recently or just in your experience that I guess like frowned upon or whatever within the syndication? Because I've heard that, if there's somebody on the team that's just raising money, then that's a red flag. What else have you seen?
Let's address that first. So hiring somebody to raise capital for you, huge red flag. Registered broker dealers can raise money for you and charge a fee, okay? With the regulation CF raise, you have to use registered broker dealer to conduct the raise. However, oftentimes you'll find somebody, John knows the owner of a pension fund. John puts you in touch with the pension fund and say, hey, I just got you $20 million. I want a fee. I want a percentage of that transaction. That can't happen. There is a way to get a non-transactional small flat fee for introducing capital. I don't recommend it. I think it's too risky. I think it's gray. I don't ever recommend it but technically you can be a finder in that sense. It's to be non-transactional, a small flat fee, And I would go through many no action letters to try and figure out what that would be. But you know, from a general standpoint, you cannot pay somebody to raise capital. There is an issuer exemption. So if you all are the sponsors, you guys can raise money without, you know, but you still, even as part of the issuer, can't be paid for it, right? So you still have to be doing something else active and overt for the company that's not, I'm only here being paid for raising money. So the whole investor relations thing, you go out and try to raise cap, that wouldn't work. You really have to be, it's facts and circumstances, but you really have to be doing something over and intentional to further the company. Other red flags, not disclosing everything. PPM should be very scary. Okay, PPM is 101 reasons not to invest. That's how I approach it. It's just safer that way. So if there's ever anything that you feel might turn an investor off, disclose it. Failure to disclose is a big problem. Posting on social media. You know, if you're not doing a 506c raise, that is general solicitation, that's a big no-no. You see this also in the public arena where you've seen issues with insider trading with CEOs posting stuff on Twitter. Same with private placements. I'm the social media police. If I see my clients post stuff on social media, I'm all over it. And then going about it alone. I had a client the other day call me. Hey Mel, I've got this investor that's willing to invest money. Can you draft a PPM? We'll get the money first, do the PPM next. No, we can't do
order.
Absolutely not. Let's back up and let's do this the right way. And then you've got clients that will go and try to get a template PPM, which doesn't ever work. And I mean, there's just no one size fits all PPM for these deals. So those are all red flags that I look for, and I always think if the SEC were to come snooping around, what would they look at? Following the Form D late's another big one. In Texas, it's not that big of a deal, but in other states, you can actually lose your ability to do other Regulation D 506 raises. So those are some red flags that I look for.
You alluded to solicitation to potential investors, Melvin. I want to go back and I wonder if you can elaborate that on more. So, you know, the difference between, you know, quote unquote advertising or soliciting sophisticated versus accredited investors, there's very distinct laws between those two. Can you kind of break that down for us?
Sure. So in a Rule 506B, because you are dealing with sophisticated investors, and sophisticated investors are just non-accredited investors that are financially savvy, you can't generally solicit. Okay, the SEC really wants to make sure that you're making the proper disclosures to these investors and that you're not just trying to attract, you know, non-sophisticated or even sophisticated investors by general solicitation. So that's why I would say don't post on Facebook, you know, don't post your webinar, you know, all that good stuff. Now under 506C, you can solicit because you're going to be verifying that the purchasers are accredited investors. So, you know, I can generally solicit my deal knowing that the purchasers are going to be third-party verified, normally accredited, and again, they have that team together to help them assess and mitigate risk. Now, you have to talk about substantive pre-existing relationships also, because under 506B, that's really how you distinguish yourself from soliciting versus not. So if there's a no action letter called Citizen VC that is a really good model as to how you would show that you've got a substantive pre-existing relationship. Now, it's not the only way, but basically if you have a website, you know, you've got your business, you've got a website, you have someone to fill out an application or a questionnaire, and then you have a follow-up phone call with them or follow-up email, and they make certain representations to you about their net worth, then you've identified that, you've satisfied that substantive pre-existing relationship. You can prove it other ways. You know, it can be a best friend of yours from college. As long as that relationship exists before the issuing of any, before the offering of any securities, you're good. And it can be within 5 minutes. I can meet Cody, have a 5-minute conversation with him, and then say, oh, here's this, here's this offer, here's this deal that I'm doing. But really, that's how you distinguish yourself from general solicitation, is showing those pre-existing relationships.
Mm-hmm.
You would have to have that pre-existing relationship before you go into contract, correct? I couldn't go into contract and then meet somebody and then offer it to them, right?
Even before the contract portion, before the offering. So before you ever introduce the deal, that relationship is to be in place.
Gotcha. And I want to go back to your point you made about the social media, because I think this is such a gray area. And I know you're recommending not posting anything related to your deal, but I think all of us probably in general, in some way or form, are trying to use social media as a platform to, expand our network, expand our outreach, maybe potentially find other investors. What would you recommend as far as us trying to, I guess, in a way, promote ourselves or promote our business without crossing that area into solicitation?
So your company is Blue Oak Invest, right?
Correct.
Yep.
So, you can encourage people to come to your website where you're going to have that link to a questionnaire. You can tout yourself as having done so many deals. You can't condition the market. So you can't do anything that might suggest that you've got this deal that you're planning, but you can certainly promote your business. You can promote yourself. You can tout your experience, invite people to meetups, invite people to webinars, without saying, hey, we're purchasing this 35-unit property in South Texas. We need to raise X amount of money. Who's interested, right? You can promote yourself in your business without promoting a deal, if that makes any sense.
Absolutely.
Yeah, so going back to conditioning real quick, I've seen other people post returns, not of current or future deals, but past deals, so they're closed. Is that considered conditioning?
No, I think that's okay because the deal is closed. I think that you're promoting yourself, you're telling your experience. That's fine. It's when you have a current deal and you're trying to sway people kind of toward that, towards it. That's what I think you're conditioning, and you'd be able to stay away from that.
Got it.
Melvin, what if you're posting on social media and people start asking you if you have any deals?
I would direct them to your website. If they want more information about your business, and they'll go and they'll see that link to the questionnaire, let them fill it out. That's when you can establish those relationships, right? I wouldn't say yay or nay. I would just say, hey, you want to talk more? Let's talk. Go to my website. We'll go from there.
Yeah. I think the typical funnel that we see, it's common, is it's a web form with, name, occupation, are you a credit investor or not? Prior experience, yada, yada, and then schedule call.
Yep.
And that seems to be the standard way.
Yeah. Now, and speaking to the social media platform, we're referring to soliciting or conditioning for sophisticated investors, but accredited investors, as you mentioned before, if my business model or my business plan or intent was to recruit only accredited investors, as long as I'm not accepting or funds from any of the people that may be inquiring on, like, say, for example, a Facebook post, as long as I'm not taking their money or getting them to sign documents and I'm only targeting accredited investors, I'm still okay, correct?
And that's very rare. It's very rare that you see somebody that's doing that. But yeah, occasionally you'll see accredited investors only. We've got this deal in South Texas. It's that they're clearly structuring that deal as a 506C. That's fine. But that's very, very rare. You see people just kind of recklessly posting their deals on Facebook or Twitter, and that's wrong. And there is enforcement. It's not, a lot of people do it, but that's never an excuse.
Doesn't mean it's right.
Can't get
and I'm sure, going back to your example about the JV, where I'm sure that's probably easy to get lured into that temptation, right? Where you may try to go out there with that intent, and then people start reaching out to you, and then you start, you get easy access, but then you get yourself in trouble. So
yep.
Yeah.
Now, when it comes to SEC enforcement, here's the troubling thing. It's, if you do it, probably no one's going to knock on your door tomorrow. But because the SEC is structured, I want your opinion on this, Melvin, to protect investors. I believe that, if things start going south in a deal and enough people complain, that's probably when you start getting some investigations. Curious if you could comment on that.
Yeah, so a few things happen. Returns are looking shaky, or just, the sponsors are not responsive. You're not getting distribution checks. There's always some red flag from an investor side where they'll see something and contact the sponsor. The sponsor doesn't respond, or the answer's flaky, and then you get a federal SEC investigation. So that's normally what happens. It can also happen to where, the SEC happens to be looking around and sees that the Form D was filed really, really late, and they might let it go, then look some more, and you've just consistently filed late, that can lead to an inquiry. Or maybe you submitted offering documents to the state, you inform the state of the offering, and the offering documents seem suspect. So it's not a situation when you're doing the transaction, there's nobody looking over your shoulder, but when it's done, like you said, you get those you get those complaints and investigation. That's how we as attorneys think, what if that happens? And we structure accordingly.
So that goes back to where he's saying, like, people shouldn't be using like sample operating agreements and,
yes, absolutely.
And so
it only takes one upset investor to bring the whole thing down.
So when someone approaches you, Melvin, say it's their first time trying to do a syndication, what should they bring to you for you to start with the process, to start drafting up the paperwork?
So first, they should bring their brain. We're going to sit down, and Henry can tell you this. I have a long conversation with first-time investors as to how this process works and the different levels to it. So a lot of them, they think about it, they don't realize, again, you've got the capital raise, you've got the purchase of the property, you've got the lenders. There's a lot of moving parts. It's important that you have a team that can handle all of those things. So when I sit with somebody, I'm going to say, do you have a title company that you use? I do the commercial real estate and the syndication portion, but do you have an attorney that's going to go through the loan docs with you, or is there a fund broker you're dealing with? You've got to harmonize all of these processes into one. From there, I say, how are you documenting your pre-existing relationship? So we do it in a 506B or 506C. How are we going to structure it? Do you want an LLC with different membership classes? Do you want a limited partnership, with limited partners? And then from there, I kind of go through the process. Do you have a business plan with an executive summary? Do you have a pro forma? I kind of look that stuff over to make sure that the returns aren't ridiculous. And then, I kind of go through where I come in, where you retain me. I'm going to draft the PPM, almost a week to a week and a half, depending on how many I have going at one time. We're going to go over it. I'm going to draft all your investor questionnaires, subscription agreement. And once the PPM goes out, I'm always the point of contact. So you can email me questions directly, call me, text. I don't charge for any of that. I'll answer the questions, normally in writing. And once they're secure, once I get that first irrevocable signature and commitment to invest, I get the process started and file the Form D. So I'll send you a power of attorney so that I can file the Form D on your behalf. Most of my clients are repeat, so it allows me to do it for each of their deals. And then I'll file the Form D. I'll alert the states that you solicited investors from that the Form D was filed. I'll upload my disclosure documents. New York is very expensive, by the way. So most states, you just pay a fee. Texas is $500, Virginia is $250, but New York is $2,500 per investor. So keep that in mind.
That's for every state that, if there's an investor from every state, you've got to file in all 50.
Yep.
Yeah.
And I've got legends in the PPM that apply to all of the states, but New York is very expensive. So I've had investors that want to go solicit a bunch of big time New York, investors, and they're, you're paying that fee per investor. So just little nuances like that are why you want someone who understands corporate law and the blue sky, the state corporate law as well, to get these deals done.
Yeah, I'm glad you mentioned that, because I was going to plug that in here. Is you definitely want to make sure you're working with somebody like yourself, Melvin, right? As somebody that specializes in this SEC law. You don't want to just bring this to any other attorney and say, hey, make this happen. You're just going to leave yourself wide open. So,
right. And there's a lot of liability on our end as well. So a lot of attorneys that don't do this won't touch it. And I get lots of referrals because of that. So, we don't want anything to do with securities law. Well, I've been doing it for a while, so I don't mind it. But you definitely want a securities attorney that knows his way around. And the same with real estate. You want a real estate attorney that's going to make sure that you're delivered clear and marketable title of the property. You're going to want an attorney that's used to, go through loan documents for your lenders, So.
Yeah.
Do you have any personal experiences during the syndication process that are kind of like, unique in their own situation? Like something happened or something didn't happen that should have been done prior to the good and the bad, if you don't mind sharing.
The good is when it goes through without a hitch. Our fee is normally attached to the success of the deal. And I know that my fee, if the deal doesn't close or falls through, you get another bite of the apple. So one fee, and for me, you don't pay me until the investor invests. So with me, I might not get paid for 6 months if, 2 deals, if a deal falls through, then I'm going to wait for the second deal. So that's kind of the downfall of some of us charge up front and then that fee just rolls over. I just don't do it that way. I don't like for legal work to be a barrier to getting business done. So I try to be really mindful about that. An interesting deal, I just had a brewery that we completed the private placement and the deal closed and then it just completely fell off from there. So we're trying to unwind it now because all of the partners had a big disagreement and they walked away basically. So you want to make sure that your operating agreement addresses that type of situation where, the partners fall apart and the investors are involved in that as well. So we're having to wind that back. That was unique because it didn't normally happen that way. And again, that one situation where my client called and said, hey, I've got investors ready to go. They want to wire the funds, but we don't have the disclosure documents. Having to kind of let a client know that has this investor's expectations high that they're going to invest. Wait, we have a week and a half to 2 weeks before they can do that. That's a difficult situation. So, each investment is different.
Melvin, when speaking to, we talked about, having somebody like yourself with this, focus in this particular law to help structure these deals. But from a passive investor side, if they may, especially those who are maybe the sophisticated investor, right? We may be giving them a 100-page PPM and maybe they want to take it to legal counsel to go review it, make sure that they understand it. What would you recommend? Can they take that to any attorney as well, or should they be looking out for people like you as well?
It should be a corporate lawyer, a lawyer that knows what they're looking at, definitely. And it's normally an hour to an hour and a half consultation. And they get a pretty good sense of what they're getting into. Like I said, it's 101 reasons not to invest. So if you drafted one, that your way around it. We know exactly where to look to see where there may be red flags. Was this a template that was, printed offline? Does the attorney know what they're talking about? What is the succession plan, if anything should happen to any of the sponsors? We take care of all that. So I would definitely recommend a corporate lawyer.
Excellent. Could you give us an example of maybe a time that you ended up in maybe litigation and from mistakes that were made? We know you do a great job, so I'm sure not from your representation, but maybe, another deal that, again, they maybe not have structured the syndication correctly or lawfully, if you will. They ended up in litigation. And can you tell us maybe some of those circumstances? Have you ever been in those?
I have not personally been the subject of one, but I was just brought on to a case. It was a private placement that was done by a very prominent securities attorney out of Dallas. And she didn't file the Form D, which is the SEC's about to find that out. But the CEO of the company was just burning through cash. They raised this money and the CEO was burning through cash. She was caught on a forensic audit and investors started asking questions of the security, and the CEO is just kind of like buried his head between his legs. So that's going to be a very, very big, serious criminal issue. And I was kind of brought on to evaluate the way that deal was structured. And I'm not actually going to represent the company in front of the SEC. You've actually got to be specifically licensed for that. But I'm getting it poised to get to that point. So, but luckily I have never been the subject, or have none of my clients have ever been in litigation for securities infractions. Yeah,
that's good to hear, man. I think that, really was hoping to, number one, hear that you haven't had to go through that.
We go through the list now.
No, but really the real root of the question was really just kind of to identify, like, man, what are some of the big mistakes that you're seeing that are being made out there that are putting people in litigation? What are those mistakes that we can avoid or make sure that we avoid, so that way we're not having to have that call?
Surefire accounting. Make sure your accountant knows what they're doing. I normally see this with offshore raises. You've got Regulation S where you can raise money offshore as long as you're not doing a 506C raise. There's no general solicitation. But, make sure your accountant knows what they're doing. Make sure that you guys are attentive to the investor's needs. Make sure that, your fiduciary duty is to the investor, right? So I approach it just like I would a corporation. A corporation's officers, their fiduciary duty is to the investors. You should do the same. And make sure that you're making strides to improve that property and to produce those returns. If you gave the expectation of a huge return in your pro forma, if you weren't conservative with your numbers and you're not producing, they're going to look into your operations, and we structure it to where they can. We want to be as transparent as possible. So making sure to reasonably and prudently operate this enterprise to generate these returns, and nothing illegal. You're not, you disclosed how you're going to use the funds accordingly. So those are kind of my suggestions. And if you have any questions, call me. If you're doing a deal and you want to make a decision, maybe the investment strategy's changed, the subscription agreement allows for that, right? You guys are the sponsors. So if the investment strategy changes some, give me a call and let's evaluate how much and see if additional disclosures need to be made, or how we can kind of circle it. So a big piece of advice is keep your attorney involved. That's what we're here for.
Awesome.
Melvin, what is your take on the whole crowdfunding for real estate? Do you as in your practice, do you practice crowdfunding or?
Yep, so I'm getting ready to start a Regulation CF raise for a brewery next week, actually.
Okay.
So with Regulation CF, you can raise up to $1 million the first year, but there are limitations to how much the investors can invest. The limitations are based on their net income and net worth. And then you've got Regulation A, which is essentially a mini IPO. That's a much more expensive and much more intense process, if you will. I have not done any Regulation A work yet. I just haven't gotten the request for it. And I thought maybe for this brewery, but I think I'm up with Regulation CF. But those are your two big crowdfunding. And with Regulation A+, you can raise up to $50 million. And the different tiers, so 2 tiers of raises for Regulation A+. So I see it in the hospitality side with breweries where people want to say they own part of a brewery, or something, some business in the community that people want to be involved with. They'll go through Regulation CF raise, and they'll go through WeFunder or some broker-dealer platform to put the raise together, and we'll raise accordingly.
And I know you said, for 506B or C, there were fees for investors being in different states. So does that also kind of apply for CF as well, or not at all?
No. The disclosures are different though, but no.
Okay.
Maybe an odd question, Melvin. I was kind of thinking about this the other day. With the whole COVID pandemic going on right now, it's impacting every single sector, us as real estate investors, whatever. Has there been anything COVID related as far as maybe the law is concerned that has changed as it relates to syndication and some of these SEC laws?
So from a legal perspective, there are some relaxed requirements. So like I said, we've got to form a file, Form D, and we go through EDGAR. The EDGAR filing is going to do so. there's a notarization requirement in there that we have to follow. That was relaxed. So it just makes it easy for us to file Form B without having to go and, go to a notary in person. In the regulation CF, there was some additional time allowed, I think 45 days to give your disclosures. But really on the investor side, the COVID-19 has changed the landscape of actually purchasing the property. So I'm normally able to get an equity contingency into a PSA to where if you can't raise the money, you don't have to purchase the property, along with financing contingencies, or if the shutdown persists and doesn't allow for the inspection of the property, I can get it to where the critical dates are extended accordingly. So really, with COVID-19, we're seeing that impact the purchase of the property more so than the capital raise.
Now, are there deadlines associated with these changes, or this is something that's going to be ongoing until?
July 30th, I believe, for the notarization requirement. I'm not sure for the regulation CF disclosure. I have to check that, but I think July 30th, and we have to go back to under those circumstances getting the form D notarized before we get our access codes.
I gotcha. That's the first time I've heard of that. I mean, we've heard of different contingencies, and I've heard people say you can put contingencies for anything you want, really. But this is the first time I've heard it from a investor standpoint like that, adding that contingency. That's
you weren't seeing a lot of that, but we're seeing now like minimum rental guarantees. So I just got into a PSA clause where a certain amount of money is escrowed for a few months, to guarantee a certain amount of rental for those months, and if once it's met or if it's not met, the rest goes to the seller. I'm getting equity contingencies in, financing contingencies. So COVID has helped those types of situations.
That's good to know. Yeah. Anybody else got any questions?
Where can we contact you at?
Oh, so I can be reached at my email is mferebee, my last name, at TFG Firm. Is there a chat? There's a chat.
Yeah.
Yeah,
there is. Yep.
I'm gonna put it in the chat. mferebee at tfgfirm.com. My phone number is 757-218-7515. You can text me. You can call me anytime. My website is tfgfirm.com, but I'm getting that overhauled, so pretty soon that'll be under construction. And actually, you know what? I believe the broker-dealer takes care of the state verification regulation CF, but I'm gonna research that for you to make sure I was correct on that. I'm gonna double check that.
Thank you.
And I'll get back to you.
And Melvin, for those that are on the call, you are based out of Houston, right? You're here, here in town. So, but you can service, or you can draft these documents for anywhere within the state of Texas and whatnot, correct?
So for the purchase of the property, that's a state law matter. I can do that here in Texas. So if you're purchasing property through a syndication here in Texas, I can do the capital raise, and I can take you through the underlying purchase of the property. I can make sure you're delivered clear marketable title. I do all the title diligence and all of that. In some cases, they'll have me do the loan docs as well, or they'll have another attorney do that. But all around the nation, I've got clients doing syndications. That's federal law. So I'll come on to the capital raise, and they'll have local counsel that will work on the underlying purchase of the property.
Gotcha.
What about, I have actually a question actually. If you were to look at doing properties in other states, we live in Texas here, most of us, extra BJ, where's BJ?
Cali.
Yeah, from Cali. But let's say you want to do one in a different state. Do you need local teams in each area?
So,
I
can do the purchase, I can do the capital raise syndication. You're going to need a local attorney to draft the PSA and to do title diligence on the actual property. That's a state law matter, and the property laws are different, especially in Louisiana. It's like the Wild West. But you'll have me to deal with the federal law stuff, and then local counsel with the state law, and we can, he and I can harmonize, or she and I can harmonize, and make sure that the deal goes accordingly, smoothly.
Okay, sounds good.
All right. Well, if nobody else has any questions, Melvin, I want to thank you so much for your time, man. This has been great conversation. And we'll definitely be posting this. We'll send this link out to you and to everybody else. And, definitely plan on sharing this with as many people as you can. I think this is such an important topic. And if you're going to be raising money, you absolutely have to know this side of the business. So
yeah, and Melvin's an open book. I mean, we've had some questions, and he's happy to come back to us fairly quick. So absolutely ask him a question. Hit him up on his number, his email on the side.
And little plug for you, Melvin. You're the most responsive attorney I have ever dealt with. So he's on it, man.
I would agree.
So we appreciate you, man. It's so great to know you and be able to work with you. So thanks for being here.
Appreciate it.
Thank you, Melvin.
Thank you.
Thank you.